Welcome back, everybody, to another I'm not taking that plea deal, ma'am. I can get better episode of Lockdown 23 in 1. That's right, today we're jumping back into a Texas courtroom to witness a defendant get sentenced for multiple probation violations. Not to mention he brought back an unspeakable fresh crime. First though, of course, if you're new to the channel and enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today.
32623.
Looks like we got a little bit of a lag
we
here.
We have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalvius Williams, and Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So
all right, let's allow the ex-con to break down some of the courtroom verbiage. I do believe that this individual's in court right now for a probation violation of 3 offenses, but he has a fresh crime that he hasn't been convicted for or went to trial yet. And typically when people go through situations like that, the judge said they'll set up a new date. Usually they wait till that trial, see if they're going to be found innocent or guilty, and then do the probation violations. Because if they're found guilty, then they need to add that as a brand new violation to the 3 that's already there. They don't want to have to keep going back and forth in the courtroom, so she's giving them an option as well to drop all the pleas that he already made to the 3 counts that violated him, and without even going to trial or anything like that for the 4th new crime that he brought back, she said she's going to go ahead and kind of throw it into the mix with what they got now, which doesn't really make too much sense to me because he still has a chance to fight it in court and be found not guilty. Kind of confusing, I know, but you know, that's how probations and violations work, man.
Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back,
Just
count
3?
1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022.
No bueno.
You had previously pled true that was true. And do you want to continue to plead true to that count? Okay.
All right, so the first violation he's in the courtroom for is not showing up to probation whatsoever. Absconding, I don't know how you pronounce it. That's how I've always said it, but that's like the worst possible thing you can do. It's disrespectful. It looks like you're spitting in the face of the courts, man. You don't care about anything that they said if you ain't showing up to probation whatsoever. And I like to correct myself, all right? It's not the worst thing. What's worse than that is bringing back a fresh crime, and he done did both of them. This guy's going straight to Smokeville, guaranteed. But let's listen to count 2, I believe, on what violated him.
And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638.
That's sad, man. Look, I lived on probation from like 14 to, I don't know, 28, something like that. It was a rough ride, but you're never lonely, I'll tell you that. That probation officer's always by your side. Anyways, one thing I learned throughout time going to jail and prison and being on papers myself is if you pay them fines, I can almost guarantee you're going to get off them things way sooner than you ever imagined. I got off 1.5 years early when I paid my fines. Any other time I was on probation, I couldn't pay my fines all the way. I kept going. Never let me go, right? So, just a huge piece of advice. Pay your fines. You'd be surprised the wonders it would work. Let's roll in to see what happened in number 3. This is the one that he's going to decide not to plead true to.
previously pled true to that count, and do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count? You want to change your plea to not true? Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge.
Okay.
They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
So we need both of them.
Okay. Okay. All right.
So like I said, he's going to fight the third one, which says he was fleeing and eluding the officers. That's pretty much going to be an open and shut case. I mean, he just said the officers seen him walking out the back door while they were knocking on the front. Can't beat that, man. He say, she say. Think they're going to go against what the cops say? Hell no, man. Probably got body cam footage and everything. But either way, it doesn't matter, man. Those other 2 are going to get him smoked. So might as well just plead true to that one, man, and throw yourself at the court's mercy. You're just giving him kickback now and adding strife to the trouble.
Right, so we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes,
oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand.
She said she pulled up the indictment of injury to a child. That must be his new charge that he's bringing back. The 4th one that's kind of throwing a mix into everything. And that is not the kind of crime you want to have going into lockup.
That if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand?
And this is something that I was always terrified of going through when I was on probation. Look, what she means by stacked is she could go through these violations right now, sentence him to the 4-year cap, which means they can't give him no more than 4 years. But if he's found guilty on this new charge, he's got to go through the process again and everything's going to be double. Man, this guy's stuck between a rock and a hard place. There's some big decisions he has to make.
Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were and all of that this morning. Is that correct as well?
Correct, Your Honor.
Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table on this case.
Wow,
Okay.
man, wow.
I apologize, Judge, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime someone, the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time.
Okay, so he has to plead guilty to that harming of a child crime today. Yeah, I wouldn't take that plea deal either. I can't ride out that kind of charge, man. I gotta fight it tooth and nail. So I kind of understand where he's coming from, not taking the plea, I think.
You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward.
Keep in mind, too, look, 4 years is a lot of time, but it's not that much time. Now let's add causing harm to a child in your rap sheet. That 4 years just turned into a possible death sentence. Because in the majority of prisons across the country, they ain't gonna be living with nobody like that in a cell block.
And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do?
True to the first, but not to the injury to the child.
Okay, then we'll go forward with this hearing.
All right, so it sounds like he wants to plead true to everything except for this harming of the child situation.
Want to make sure also for the record, what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2.
All right, so the PSI, believe it or not, is very important in these type of cases. We call them pre-sentence reports. All right, it shows your background to the judge, how much bad you've been doing, and how frequently. Then you add up all those dirty bad points that you made throughout your life, and some kind of system, works out how much time you should be getting. Helps keep everything balanced, especially for the judge, not getting too muting time or too less. Letting equations solve it for the most part, but they still have an opportunity, the judge to go above and beyond guidelines.
On that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, ma'am.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail.
This guy's a frequent flying jailbird. My lucky stars, he's the misto champion. Misto's short for misdemeanor to me. And that's typically what happens with the misdemeanors. You can't get no more than 12 months, so guys go in and out, typically for like a month or two here and there.
The felony criminal history I show is a criminally negligent homicide from 2017.
What?
Where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon. Also same disposition date of January 10th of 2020 for the 12 months.
Hold on, man. This guy's already been convicted for one time of harming a child? And he had a violation for a negligent homicide? You heard what the judge said. Running back to his paperwork, I don't know what we were thinking. I gotta see what kind of probation violation they gave him for all this stuff, man. That's unreal. He's out here in the streets.
New offense from January of 2019, an attempt to take an officer's weapon. Also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that? I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, that was the victim in that offense?
The stepson, Your Honor.
Oh.
So Ms. Broussard has other children that are not.
He pled guilty to abusing his stepson. This dude is a filthy bag of trash.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true. And at this time, I am going to find count 4 true. I understand everyone's position. I think with regard to there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report, and they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Asking for 2 to 4 years, but they were trying to give you 4 years for everything. Even the new charge. These guys, I think the attorney knows what to do. The defendant just don't want to do it. You can lead a horse to water, but you can't make him drink.
Judge,
Mr.
I
Smith?
believe his criminal history shows very convincingly that he is unable to successfully complete probation. Speaking of probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports.
Jail incident reports, keep in mind, you keep getting in trouble in jail, they'll let the judge know when you go to trial. Or violation, one or the other, man. And it really shows that you ain't learning nothing. Watch your P's and Q's even when you're in the cell block.
I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
You know, ma'am, I concur with the district attorney.
Okay, thank you, sir. And Mr. Williams, you're 30 years old? You just turned 31.
Oh, man.
So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own.
Nope, he's a menace.
Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, it's ridiculous. You and Ashley both don't need to be around any children.
Oh,
Don't need to be
man.
having more children. You can't take care of your own children, and you're disciplining them by doing this. No one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old.
2-year-old? Oh, my. Finito, finish him.
Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily.
Bobby,
Find
cue
those
it.
counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive
8
credit on that
clip.
sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification.
Smoked
I'm making a notation on this because originally it was a plea agreement that when it was signed, I'm making a modification.
He turned down a 4 clip for these charges and the new one and got 8 just for these. And now he has to go through the other court process and all this over again where it could be stacked to what, 16 years? Oh my goodness. I love it. That smoke will lead you
Regarding-
right to your
Hold on
bunk.
a second.
Child abuser, man.
Regarding your ineligibility to possess a firearm
Bottom
or
of the
ammunition.
barrel.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
Well, there you have it, ladies and gentlemen. A prime example of screwing up probation in the worst possible way, man. Bringing back fresh charges against children. This guy's going to have a rough ride in the Texas Department of Corrections. And that brings me into my next video. Stay tuned. I got a former guest coming on to do a little recap. He did 8 years in the Texas Department of Corrections, and our first interview did about 150,000 views. Not only is he going to do a little recap of his story and his life and what's going on with him now, but also he's going to give his 2 cents on the Carmelo Anthony case. He's been following it. He's going to break down exactly what he could be facing in the courtroom all the way into prison. I'm really looking forward to it. I'm not going to lie. So stay tuned, ladies and gentlemen, and the only way to do that is by hitting that notification bell, setting it to all. In the meantime, though, as always, y'all be easy, be safe, and more importantly than anything, don't dig yourself a bigger ditch. Definitely don't be hurting no kids. And stay free.